Well, good morning, everyone. I'd ask everyone to take your seat at this time. And I want to welcome all of you, in particular the justices of Michigan's Supreme Court, to the campus of Northern Michigan University on this beautiful late September morning. It couldn't be more perfect outside, and I'm so excited about what's going to happen in this room over the course of the day. Of course, we're here on our campus at NMU for the 30th Court Community Connection Program. And I want to welcome everyone in attendance, but in particular the students, both the high school students and students from Northern Michigan University who have the opportunity to participate in what we see as a really exciting learning experience and a perfect example of experiential learning, civic engagement. It's something that I know our community holds dear, the state of Michigan holds dear, and Northern Michigan University holds dear. Now, before I get started, I do have the pleasure of offering a trivia question to all of those in attendance and perhaps to our commissioners and justices as well. I wonder if anyone knows the 4 Supreme Court justices who've hailed from the Upper Peninsula. And this is a good trivia question for your president as well, being a relative newcomer to the Upper Peninsula. But they are Paul Adams of Sault Ste. Marie, Richard Flanagan of Ontonagon, and then later Marquette, Michael O'Hara of Menominee, and of course John Volker of Ishpeming. And we know that Honorable Judge Volker was a student here at NMU, and he was on this campus long before his judgeship, and then later, of course, before his fame as an author. I would draw your attention to the NMU archives, which are a wonderful resource in many different ways, but they're also the home to Judge Volker's papers, and so worth a visit if you're interested in his career. At this point in time, it's my pleasure to welcome 2 individuals to the podium. The Chief Commissioner of the Michigan Supreme Court, Daniel Brubaker, and also Commissioner Liza Moore. Commissioner Brubaker and Commissioner Moore, I welcome you to the podium. Have a wonderful day, everyone, and welcome again to Northern Michigan University.
Thank you so much. Good morning, everyone. My name is Dan Brubaker. I'm the Chief Commissioner, what's called the Chief Commissioner of the Michigan Supreme Court. And I'm here this morning with another commissioner from my office, Liza Moore. And our job right now is just to provide you a little bit of history of the Michigan Supreme Court and the justices, and to provide an update of kind of what the case is about. So first of all, there are 7 justices of the Michigan Supreme Court. That's the latest picture of all of them right there. The Chief Justice is elected by her fellow justices. It's a little different than the federal system. So in our system, the other justices voted and elected Elizabeth Clement as the Chief Justice of the Michigan Supreme Court. Before joining the court in 2017, Justice Clement was counsel for the executive branch. The next justice to talk about is Justice Zara. He joined the court in 2011. He was a circuit court judge, and he was also a Court of Appeals judge, and he teaches at the University of Detroit Mercy Law School. Justice Viviano is next in seniority. He joined the court in 2013, and he is from Macomb County, where he was a circuit court judge there. And Justice Viviano right now serves as the court's point person on electronic filing, and e-filing we call it, and technology issues, and it's really changed the way courts operate in some significant ways. Next up is Justice Bernstein. He joined the court in 2015. Prior to being elected to the court, Justice Bernstein was in the Public Services Division of the Sam Bernstein Law Firm, where he advocated extensively for disability rights. Justice Kavanaugh is next. I actually had the honor of working with her father, Justice Michael Kavanaugh, when he was here. Justice Megan Kavanaugh grew up in East Lansing. She joined the court in 2019 after many years in private practice as one of the state's top appellate attorneys. Justice Kavanaugh is also the Supreme Court liaison to the tribal courts. Next is Justice Welch, who took the bench in 2021. She is our only justice from Grand Rapids, which is my hometown. And before she became a justice, she practiced labor law, first with some very big law firms, and then she opened her own practice. And she also served on the East Grand Rapids Public Schools Board of Education. Our newest justice is Justice Bolden, who joined the court just in 2023. Before becoming a justice, she was a state representative in the Michigan House of Representatives. She worked extensively on criminal justice reform and legislation to protect survivors of sexual violence. So the way that it works is the justices are elected to 8-year terms unless they're appointed to fill a term. And it's kind of like, as you can see, it's kind of like a pyramid there. There's a lot of like district and circuit courts, which are kind of at the bottom, what we call the trial courts. And then next up, if you want to appeal from one of those courts, you go to the Court of Appeals. And the Court of Appeals has offices in a few different areas of the state. And if you want to appeal from the Court of Appeals, you then go to the Supreme Court. It's kind of the same in the federal system, but the Michigan Supreme Court is kind of the top of the pyramid in the state system. I should mention, there's only one Supreme Court office, and that's in the Hall of Justice in Lansing. Unlike the lower court, the Michigan Supreme Court doesn't have to take cases. Parties have to, and this is what's going on today, parties have to ask the court to take their case. And we get about 1,400 to 1,600 applications every year, and we will only hear oral arguments in about 80 of those cases. So this is one of the cases that we're hearing argument in. And the court is generally, of course, interested in cases that are kind of important to the state as a whole, to the citizens of the state as a whole. One thing that's different about, I mean, we've all seen TV and there's these courtroom dramas. One thing that's different about appellate courts is there are no juries. Essentially what's happening here is each side is attempting to persuade the court that something went wrong in the lower courts, either in the circuit court or the Court of Appeals. In this case, the parties are arguing over whether the circuit or whether the Court of Appeals got it right. There are no objections, there's no witnesses. Parties, if one attorney is talking, another attorney can't jump up and say, objection. That's just for the trial courts. Here, each side gets their say, they get their minutes to speak. There's no interruptions from the other side, but of course, the justices may have questions, and they almost always do, and so they can jump in and ask questions. That's it for the Supreme Court overview, so I'm going to turn it over to Liza, who will give you a briefing on the case itself.
Thank you, Dan. Good morning, everyone. We're so pleased to be here, and it's going to be exciting for us all to get to see the work of the Michigan Supreme Court in action today. I'm here to provide some background information about the case that the court is going to be hearing today, People versus Armstrong. In 2020, a police officer allegedly smelled marijuana emanating from a Jeep Cherokee that was parked on a residential street. The police officers surrounded the vehicle and talked to the woman that was sitting in the driver's seat and the man that was sitting in the front passenger seat. The police directed the man in the front passenger seat, the defendant in the case here today, to exit the vehicle, and they found a firearm under the front passenger seat. The defendant was charged with carrying a concealed weapon, felon in possession of a firearm, and felony firearm. In circuit court, he moved to suppress the evidence, arguing that it was the fruit of an unlawful search and seizure in violation of the Fourth Amendment. There are several multi-part issues that the court's going to be hearing today. First, whether the Michigan Regulation and Taxation of Marijuana Act that was enacted by the voters in 2018 supersedes a 2000 Michigan Supreme Court decision, People versus Kazmierzak, that had said that the smell of marijuana gave probable cause to search a vehicle. If so, whether Kazmierzak has been superseded, whether the evidence collected from a search that was in good faith reliance on Kazmierzak would be excluded by the exclusionary rule. Alternatively, if Kazmierzak had been superseded, whether the smell of marijuana would be reasonable suspicion for an investigatory stop under the 1968 United States Supreme Court case of Terry versus Ohio. And if so, whether the circuit court erred in determining that the firearm located in this case was not in plain view during an otherwise constitutional Terry stop. A lot in those issues. Let's break them down a little bit. How many people have heard of the Fourth Amendment? Probably everybody, right? The Fourth Amendment and its counterpart in the Michigan Constitution guarantees people the right to be free from unreasonable searches and seizures. For a search to be constitutional under the Fourth Amendment, a police officer needs to show that they have a warrant or that their conduct fits an exception to the warrant requirement, such as an object being in plain view or probable cause, that there might be contraband in a vehicle. Evidence that's collected in violation of the Fourth Amendment is generally prohibited under what's called the exclusionary rule. In 2000, when marijuana was illegal for all purposes under Michigan law, the Michigan Supreme Court decided People versus Kazmierzak and said that the very strong smell of marijuana emanating from a vehicle gave probable cause to search that vehicle. In the Michigan Regulation and Taxation of Marijuana Act that was enacted by the voters in 2018, generally decriminalized under Michigan law the possession and use of certain amounts of marijuana by adults aged 21 years or older. But that act did not allow the use of marijuana in a public space, not allow smoking marijuana in the passenger compartment of a motor vehicle on a public way like a road, and did not allow driving under the influence of marijuana. So with that backdrop, let's turn back to the facts of this case. As I mentioned a moment ago, defendant was charged with carrying a concealed weapon, felon in possession of a firearm, and felony firearm. In circuit court, he moved to suppress that evidence on Fourth Amendment grounds. The circuit court granted his motion and dismissed the case, saying there was no probable cause, and the smell of marijuana didn't provide probable cause, and the gun was not in plain view. The prosecution then appealed to the Court of Appeals, which affirmed in a published decision. The Court of Appeals said that People versus Kazmierzak had been superseded by that 2018 act by the people, and said that the smell of marijuana alone was not probable cause to search a vehicle, although it would be something that could be considered in determining whether the totality of the circumstances gave probable cause. And they said the gun was in plain view. The prosecution then filed what's called an application for leave to appeal to the Michigan Supreme Court. And the Michigan Supreme Court ordered oral argument on the application. That's what the court's going to hear today in just a few minutes. The parties submitted supplemental briefs, and some other groups submitted briefs too that are called Friend of the Court briefs or amicus curiae briefs. There are 3 entities that are going to give oral argument here today. The prosecution, they're the appellant. The defendant, that's the appellee. And the American Civil Liberties Union of Michigan, one of the amicus parties. The Supreme Court directed the parties to address those 4 multi-part issues that I mentioned a moment ago. Whether the Michigan Regulation and Taxation of Marijuana Act superseded that People versus Kazmierzak decision regarding the smell of marijuana and probable cause. If so, whether the exclusionary rule applies to evidence that was collected in good faith reliance on Kazmierzak. Alternatively, if Kazmierzak has been superseded, whether the smell of marijuana provided reasonable suspicion for an investigatory stop under Terry versus Ohio. And if so, whether the circuit court erred in determining that the gun was not in plain view during an otherwise constitutional Terry stop. So that's what the court's going to be focused on here today. Students, as you listen to this, think about how this decision on the smell of marijuana and the Fourth Amendment could affect other cases. I hope that you have lots of questions and that you think of more questions as you're watching the oral argument. There's going to be a special time for you to ask those questions after the oral argument has concluded. So hang on to those questions until then. So with that, let's proceed, and I'm going to turn things over to Jeff Mills, the court crier.
Persons having business before this honorable court are admonished to draw nigh and give their attention to the court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Good morning. Welcome to the 30th Court Community Connections program. Before we dive into today's case, I want to extend my heartfelt thanks to our hosts, the students, and the educators who have joined us today. We are thrilled to welcome students from the following schools: Ishpeming High School, Northern Michigan University, Rapid River Schools, and Republic Michigamme School. It is a great honor for my colleagues and me to be here at Northern Michigan University to mark our 30th Court Community Connections event. This milestone highlights our ongoing commitment to community engagement, collaboration, and building public trust. I would like to extend special thanks to Northern Michigan University and especially President Brock Tessman for hosting this event and supporting local students. Our esteemed local and tribal partners from the Keweenaw Bay Indian community who have contributed to making this event successful, and the local attorneys who have volunteered their time to brief our students on today's case. This event represents the culmination of extensive collaboration and effort, more complex than any previous court community connections. We deeply appreciate everyone who has contributed to making this event a success. We are also grateful for the support of the Michigan State Police, the Marquette Sheriff's Office, and all local law enforcement agencies. I'd like to extend a warm welcome to those watching the live stream as well. Before we proceed, I am honored to introduce Chief Judge Cheryl Hill of the 25th Judicial Circuit and Probate Court for Marquette County. Chief Judge Hill has been an invaluable partner in making today's event possible, showing exceptional hospitality to the court and demonstrating outstanding leadership and commitment to both the local community and the justice system. Her dedication to fostering collaboration between the courts, local schools, and the community is truly inspiring. Please join me in welcoming Chief Judge Cheryl Hill to the stage for a few welcoming remarks and to introduce our special community guests.
May it please the court. Good morning. Thank you very much, Chief Justice Clement. You know, we have a state motto in Michigan, and it is, if you seek a pleasant peninsula, look around you. Well, on behalf of the Yoopers present here, we welcome you to the Upper Peninsula. We are so happy to have you all here today. You know, we're very happy that you made that trip across the mighty Mac. You came across that Mackinac Bridge to see us. Now, there are other judges here today who've made trips from all over the Upper Peninsula, and I would like to introduce them, and they'll stand when I call their names. Chief Judge Carl Weber. Judge Nick Davatella. Judge Thomas Slagle. Judge Janice Burgess. And Judge Julie Lacoste. Now, I mentioned the Mackinac Bridge, and the Mackinac Bridge truly is a connection, a bridge between the Upper Peninsula and downstate. It can be a physical thing, but a bridge can also be something else. It can be a social connection. That's how I view the program that the Supreme Court has brought to us today. When the Supreme Court contacted me and said, would you help? I'm like, absolutely. I am a proud Yooper. I would love to have the justices come here to experience what we have in our Upper Peninsula. But I'm also a very proud member of the judiciary. And I wanted you all to be able to see justice in action. And that's what we're going to be able to do today. You are getting an experience that very few people, even very few lawyers, get to see the Supreme Court actually decide a case. This is really special. Now, they brought a gift to us. They came to see us, so we should give them a gift. And I was trying to think of what represents the Upper Peninsula. Well, I did take them to the island last night, and I got to see the big lake, and of course they went over the bridge. But I really got to think about music. That's something we all can relate to. And we have a very diverse community in the Upper Peninsula with a lot of good musicians. Well, I was very fortunate that I was able to contact the Summer Cloud Singers of the Keweenaw Bay Indians. They are going to perform for you today, but I want to tell you who they are. They're very special people. We have Raceland Awanope. We have Raceland's wife, Dana. Who you can't see in that little buggy is baby Alice. She's about this big. She is so adorable, but she is here as well. We also have Marty Curtis and Mr. Leroy Gothier. We bring to the Supreme Court a part of our community. The Summer Rain Singers will be singing an honor song. When they sing an honor song, it is appropriate that we all stand. So if everyone would stand.
Hey, hey,
Thank you, Chief Judge Hill, for your inspiring words and continued support. Let's also give another round of applause for the Summer Cloud Singers of the Keweenaw Bay Indian community. Thank you so much for joining us today and making today extra special. A few housekeeping items before we start. First, with the exception of media and professional photographers, please refrain from taking photos once oral arguments begin. There will be ample opportunities for photos during the reception afterwards. Second, please turn off all cell phones for the remainder of the proceedings. And following oral argument, please remain in the courtroom for the debriefing with counsel. Michigan Supreme Court Chief Commissioner Daniel Brubaker will moderate this session. Oral arguments are a vital part of our appellate decision-making process. The questions and issues discussed today will help us determine the outcome and may influence future cases. By the time of oral argument, we have carefully reviewed the briefs, lower court records, and legal issues. The questions we pose and the answers we receive assist us in crafting a clear and accurate statement of the law. You have already been briefed on the case and come prepared with your own questions. As the court issues its decision, you will have the opportunity to analyze our ruling and consider whether you agree or would have approached it differently. Our goal today is to enhance your understanding of the rule of law and its role in our constitutional system. My hope is that this experience will inspire you to learn more about the law and explore potential careers in the justice system. Now it is my pleasure to call the case People of Michigan versus Jeffrey Scott Armstrong. Thank you. Good morning. You may begin when you're ready, and you may save time for rebuttal, but we ask that you keep track of your own time. And it is my understanding that we have 5 minutes for the ACLU as well.
Okay. And good morning, Your Honors. John Voitala, representing the appellant in this particular matter, the people of the state of Michigan. Certainly, attitudes towards marijuana have changed in the last few decades. And as evident by, if you're driving the streets of any particular city here in Michigan, you see the billboards for dispensaries, you see ads in the newspapers for dispensaries. Certainly attitudes have changed for the relaxation of marijuana laws. And that is certainly evident in the voter initiative that resulted in the passage of MRCMA. But one thing that MRCMA still finds to be unlawful is the smoking of marijuana in public, and especially in a vehicle or around a vehicle. And that's the starting point of this particular case, is that these particular officers were in an area. The Officer Eaton noticed the smell of marijuana and did an investigation of the vehicle based upon that. Upon doing so, simple Fourth Amendment applications applied after that. Following Mims, the U.S. Supreme Court case, the officer asked the defendant to step out of the vehicle. At the time he stepped out of the vehicle, that is the point in which marijuana has nothing to do with this case. At this point, the officer's partner, Officer Ganau, I believe is how you pronounce her name, she noticed the gun that was sitting at the feet of the defendant who was sitting in the front passenger seat. And at that point, there was probable cause that the defendant was committing a crime, the possession of a concealed weapon, and at that point, that probable cause allowed that officer to reach into the vehicle and retrieve that gun. That's what happened in this case.
So isn't the critical inquiry is whether or not the smell of marijuana alone
Yes.
is sufficient to establish either, I know the lower courts, and it was argued below by your office and others, that it was a probable cause standard, right, and Kazmierczak. So whether it's probable cause or reasonable suspicion, right, that your argument, your theory of how this is perfectly legal depends upon the smell of marijuana alone be sufficient to establish reasonable suspicion for the officer to be where she was at that time, correct?
Correct, and that was what the investigation was. She did indicate also that she saw furtive gestures The lower court judge, the circuit court judge, Judge Hood, had indicated he did not believe her particular testimony in there, but he did find that she did find the smell of marijuana. While I say it's reasonable suspicion and not probable cause, as Kazmierczak says, Kazmierczak was the probable cause to search the vehicle, not whether or not it is proper or whether the smell of marijuana provides the reasonable suspicion to investigate in the first place. In Kazmierczak, it was a traffic stop involving speeding, so there was reasonable suspicion independent of the smell of marijuana.
Where do we draw the line with the smelling of marijuana? Because as you indicated, you know, on our drive from Lower Michigan, lots of shops, right? Marijuana shops, lots of billboards, and just like you're seeing an increase in that, you're also smelling an increase in marijuana. At least I've experienced that. Where, you know, I've been places and I don't think it's in use, but it has a very strong scent to it. So where do you draw the line between smelling marijuana and it could have been used prior to getting in the vehicle versus, you know, it's being used or was recently just used in the vehicle?
Okay. Well, I think the smell in itself, because it is a very distinctive smell, certainly would allow a trained police officer to recognize that at some point someone was smoking some marijuana. In this particular case, they were able to focus that it was coming from this particular vehicle. And so I would think...
But that's actually my question,
Right.
is at what point, I mean, where's the training to say it was smoked, you know, within the last 5 minutes while they're in the vehicle versus it was smoked an hour ago?
Right. So reasonable suspicion in itself does not require that you eliminate all innocent explanations for this. So it could have been that the marijuana was smoked before they got into the vehicle or not. I think where I would draw the line, at least for reasonable suspicion, is that, and I've certainly encountered this because, as you said, I've encountered the smell of marijuana quite often, just in my travels around the Detroit area, is that if you're able to determine that it's not just the smell of marijuana that's somewhere in the area, but determine that the smell is strong enough that you can pinpoint it to a particular vehicle or a particular person, independent of you seeing actually the smoke coming from them smoking it. If you're able to, the strong enough smell, which the officer is trained to do, as indicated in Kazmierczak, what they said, if that smell is strong enough and you can focus it upon a particular individual, particular car, then that would provide the reasonable suspicion.
Well, isn't that what I'm struggling with is all of those factors, a strong odor on a particular person sitting in a vehicle is potentially or equally 100% legal. So how can completely legal conduct, it's as much potentially legal as it is illegal.
Right.
How does legal conduct give you reasonable suspicion of illegal conduct?
Well, that's the point, is that the police do not know whether this is illegal conduct or innocent conduct, okay?
But doesn't reasonable suspicion to support a Terry stop require more than just a hunch or a guess or a chance that it might be illegal?
That's true, and that's why I indicated it's more than just the smell of marijuana, it's the intensity of the smell and able to focus it upon a particular individual, particular car. And so, as I also indicated, is that even if there are innocent explanations for why the smell of marijuana was coming from this particular individual or particular car, that does not diminish reasonable suspicion. Is the point of reasonable suspicion is that you have a suspicion, more than a hunch, but less than probable cause, that a particular crime is occurring. You go and you investigate. You investigate to determine whether a crime actually is being committed or whether a crime is not being committed. If the crime is being committed, you could, oh, I'm sorry.
No problem. I have a question, and I think the line of questioning has been really outstanding, but I guess the question I have is, if this court were to deny, what would the actual real-life consequences of that be as it pertains to driving and marijuana?
If the court was to deny what?
Basically, if we were to uphold the fact that there was no reasonable suspicion to pull over or no probable cause based on the smell of marijuana, what would the actual consequences of that be as it pertains to driving with, the smell of marijuana or the driving with marijuana.
Well, and I think you've hit upon an important little fact in this particular case too, is because this was emanating from a vehicle. In this, using the facts of this particular case, it was emanating from a vehicle. And so we are going to even more of an extended of whether or not this person is driving under the influence or is in control of a vehicle, the driver itself, not the defendant in this case, whether the driver was under the influence. And so I think the smell of marijuana, if you smell the marijuana in a moving vehicle, it's maybe a little more difficult to come up with a reasonable suspicion. I will concede that point. You would probably need something a little bit more to get you to the reasonable suspicion if you're driving on the freeway and you just happen to smell the marijuana, because it's difficult to pinpoint. But I think in this case, where the smell of marijuana was emanating from the particular vehicle, you're able to pinpoint it to that particular vehicle, and there is a person that's sitting in the vehicle in the driver's seat. I think then that does add more to the reasonable suspicion analysis, in that you have to suspect whether or not this person has been driving under the influence.
But then if you go up, according to the video, they go up and there's, they deny using, I don't know that there was anything visible in the compartment, that there was evidence that they were actively using marijuana. Why then was there a reason to then ask defendant to step out of the vehicle? Because obviously we're trying to figure out, was there enough to get to the plain view of the
Right,
gun?
so the reasonable suspicion that gets you to investigating the particular individual, what Mims state from the U.S. Supreme Court case is that you don't need additional reasonable suspicion to ask that person to exit the vehicle. The Fourth Amendment does not require anything additional, just the fact that there is reasonable suspicion to do an investigation as part of the investigation, because this involves a vehicle, and vehicles under the Fourth Amendment are given special status. You are allowed to ask that person to exit the vehicle to further the investigation.
Sure, but Terry also stands for the proposition it's supposed to be limited in scope and limited to whatever that initial reason was.
Right, but if the police don't have to just listen to what defendant has to say when he denies his crime, because that's going to happen in every case. Is that if you ask somebody,
Is there a basis, or would it, to analogize this to alcohol? Is the smell alone of alcohol sufficient reasonable suspicion?
certainly,
Is it sufficient to support a Terry stop?
certainly the smell of alcohol on someone's, emanating from someone's breath or from their body as they're getting into a vehicle, yes, that would give
So
reasonable suspicion.
say similar circumstance, right?
Right.
I think in most cases with alcohol, right, the reasonable suspicion is probably supported by a traffic violation, right? Swerving, speeding, something. But say a similar situation where the officers come upon somebody sitting in a parked car, which could still potentially be illegal, right? Consuming it is not illegal. Consuming alcohol, having consumed alcohol alone is not illegal. Being intoxicated and in control of a vehicle would be. So if a similar circumstance, not any driving sort of situation that gives you reasonable suspicion, would the smell of intoxicant, of alcohol alone be sufficient reasonable suspicion?
I would say that it also involves, as any reasonable suspicion analysis is, depends upon the circumstances.
Factual
So
dependent.
so the circumstances that I would address for that is, much like with marijuana, it is illegal to be consuming alcohol in public. And so if you, let's say the circumstances are, you see someone outside of a bar, they have a red Solo cup, or they have a bottle in a paper bag, and you happen to walk by them, and you do get the smell of alcohol.
These are the other indicia, right? We're talking, and perhaps other indicia such as seeing smoke coming out of a vehicle or something thrown out of the vehicle, or remnants of having consumed marijuana in the vehicle. All those other indicia are still actually relevant under the Court of Appeals test, right? But the question is odor alone, and I'm wondering if there is an analogy. Like, is there a strong enough odor of alcohol that is sufficient to constitute reasonable suspicion to justify a Terry stop?
So the consuming of the smell of alcohol alone on someone that is in public, just
Right.
there's no other indication that they are actively drinking,
Or sitting in a vehicle.
they're sitting in a vehicle. Well, I guess, again, that would depend upon the location of that particular individual in the vehicle. If they're sitting in the driver's seat and you get a strong smell of alcohol coming from that person, then I think gives you reasonable suspicion.
And does our case law support that? I mean, does our current status of the law say that if you odor alone sitting behind the driver's side of a vehicle may be reasonable suspicion? I'm just wondering, I mean, it would seem to have some analogy,
Yeah.
right?
I'm not aware of any case that either says yes or no, that the smell of alcohol alone from an individual. But I think if if the police are investigating a particular car, like on a traffic stop for speeding or something, and they do smell alcohol coming from the driver, I think that does give them at least reasonable suspicion to investigate further whether it is,
Consumption or
yeah,
intoxication.
correct. Whether it's not, it's doing the field sobriety test.
Isn't
or
it a
not.
better analogy to think of open intoxicant in a motor vehicle? Because this isn't an operating offense, I don't think, was being investigated here because the vehicle was parked.
Right, exactly.
So
Well,
more of-
under the law, it could still be if the driver was smoking marijuana in a parked vehicle, there can still be some lawful
I
part of
just-
that. But
Right, I understand.
right.
I just mean the analogy with operating and looking for indicia of a vehicle that's swerving or driving erratically is a little bit different. But the analogy would be if the officer came up to a passenger in a motor vehicle parked on a public street and smelled the odor of intoxicants, would that be reasonable suspicion to investigate whether that person was drinking in the vehicle and therefore would have an open intoxicant violation?
with the smell alone and with no other indications of, as I said, a bottle or a cup or some notice that there is an actual alcohol or has been consumed in the particular vehicle, I would think that probably the smell alone is not sufficient. But I think analogizing alcohol and marijuana in a particular instance, I don't know if that is a clean analogy to be
Well, and
made.
it's more complicated too, because there is no circumstance in which having an open alcohol container in the car is legal, but it is legal to possess marijuana in the vehicle, right? You can transport it, you can do that. So it's again, legal conduct to have that. What's illegal is active consumption in the vehicle, right?
Right, and
Or
I
in
think,
public.
and I think if you're going to go down the road into Kazmierzak and you're going to analyze whether Kazmierzak is still, and I don't think you need to, but if you're still going to analyze whether Kazmierzak is still good law, I think you're inevitably going to get to the question of Kazmierzak said whether it's fresh or smoked, it means the same thing. I think what Mertma does with Kazmierzak is raise the question as to whether smoked marijuana and fresh marijuana are the same.
Or distinguishable.
Or
right? Yeah.
distinguishable. I think because you have burnt marijuana in this particular case, I think the burnt marijuana is indicative of recent use. And the recent use is the reasonable suspicion to investigate as to whether or not the using of the marijuana has occurred in a public place, which is unlawful.
I've got a question for you. You can give me a short answer, and then when you come back up, maybe elaborate further after you hear.
Well, I did forget to reserve the 2
I'm-
minutes. I wasn't
You're gonna
looking at my
have
time.
one, you're gonna have
we're gonna
1
give you a
minute.
minute.
I'm gonna have 1 minute, so I will reserve my 1 minute.
A
and
brief
I'll-
answer to Justice Sarah, and then you'll
Thank
have a
you.
minute.
Let's assume you're right, the officers were able to lawfully seize the vehicle and investigate and remove defendant from the vehicle, and assume further the handgun is still not in plain view. Is there any evidence, in addition to the smell of marijuana, that would have given the officers probable cause to search the vehicle?
Well, obviously, in this particular case, Kazmierzak is still good law, and so they would have the probable cause under Kazmierzak if we get down to that particular level to search, and I think it would be, they're in good faith, would rely on Kazmierzak to do so. I think,
You can give it to me when you come back up.
Right.
Is there anything else besides the smell of marijuana? And you can give me the answer when you
aside
come
from,
back up.
aside from the gun and aside from the marijuana,
Well, if the gun's not in plain view, is what I'm saying.
if it was not in plain view, would they have been able to go into the vehicle under Kazmierzak? Yes. I mean, sorry, you're saying without the smell of marijuana, would they been
No, no.
able to go in there and
Yeah, but
search
that's
it?
correct.
Right. I don't see a reason for doing so, but in this particular case, because he had stepped out and in plain view, they did see the gun, there was probable cause to go in there. Thank you.
Good morning, Justices. My name is Andrew Sullivan. I have the distinct honor of representing Jeffrey Armstrong in this case. I welcome your questions at any time. Apart from answering your questions, I did have one point in response to the government's arguments just now. It seems that the government is arguing this is more than just the smell of marijuana, but that it's also the smell of burnt marijuana, or it's also the smell of a localized sort of way in which the officer is able to smell marijuana. And I just want to emphasize that police did not find any marijuana in this car. And so the court should be concerned about the rate of false positives. And I think that the Minnesota Supreme Court, when addressing this question, actually cited to a study that found that in 3,300 searches of vehicles premised on the smell of marijuana, officers only found marijuana in less than 10% of those cases. And actually, Kazmierczak speaks to the fact that there needs to be some evidence of an officer's training and ability to smell, certainly any distinction between burnt versus raw marijuana. But again, I think that the court should be concerned about the rate of false positives and the fact that there was no marijuana found in this case.
Can you help me? So, picking up again, and maybe it's an inapt analogy, but the presence of alcohol, whether it's from consumption or open alcohol, there is some Court of Appeals authority, obviously not binding on us, but that says that a strong odor of intoxicant standing alone can be sufficient to support reasonable suspicion. So in light of that, what do we say about why can't, assuming even under Kazmierczak and after Murtma that probable cause is sort of off the table, or that the Court of Appeals sort of analyzed that correctly of it takes more than that, why isn't the smell alone at least enough to establish the lesser standard of reasonable suspicion?
The smell of marijuana and the smell of alcohol are chemically different, and so I think that the legal analysis has to be correspondingly different. When officers smell alcohol, they're usually smelling it on someone's breath. The smell of marijuana, the chemicals that produce the smell of marijuana can adhere to clothes and upholstery, fabric in a car, and that smell can linger for days, hours, unlike the smell of alcohol. And so when an officer is smelling alcohol, it's telling them a lot more about, one, who is consuming that alcohol. They're smelling it on someone's breath. They know who's consumed it. And two, how recently it's been consumed. And that information is not available to the officer just based on the smell of marijuana, because it could be that the individual was just in close proximity of someone else who is smoking marijuana, so the officer doesn't even know, is this the person who has consumed marijuana? And also how recently that person has consumed marijuana. And so I think that those distinctions...
But do we really need experts to know? I mean, it's so prevalent. I'm driving down 96 in my car on the freeway, and I'll go by a car and I can smell a strong odor of marijuana. Do we really need experts to tell us that's a really strong smell of burnt marijuana? That's not fresh marijuana that hasn't been smoked, and it's recent. I mean, isn't that ordinary observation? Do we really need that? And if there is this strong smell coming from a car with a person behind the wheel, under Terry, isn't that enough for reasonable suspicion to at least go on and ask more questions and find out what's going on?
So first, taking the first question, it's the smell being very prevalent and people feeling as though we can all identify that's the smell of marijuana. I'm not disputing that, but I am disputing whether or not our simply smelling it is actually proof positive that it's exists, that it is where we think we'll find it.
But Terry doesn't require proof positive, right?
Certainly, but Terry does require reasonably objective, particularized suspicion of criminal activity. And given that marijuana is legal to have for a person to have on their person, and it's legal for a person to have consumed yesterday, it's legal for a person to have been in a room with someone who's consumed yesterday, all of those possibilities, I think, discount an officer feeling as though they have reasonably objective, particularized suspicion of criminal activity.
So what more do you need? Let's use the circumstances of this case. What, if smell is not enough, it's smell and what? Can you give us some examples of what could have been enough?
Certainly, the circuit court made particular note of the fact that the officers did not see any lit cigarette, any smoke billowing out of the car. Those would have been indicia of present consumption. And so officers would have been more justified in having some concern that maybe a person is, again, the present consumption on the roadway is only a civil infraction. So I'm not sure that that even gets them suspicion of criminal activity. But if maybe in addition to seeing the marijuana in the car, if the car was running, if the car was moving, then there may be concerns that somebody is operating a vehicle under the influence of intoxicants. But none of those things are present here.
So I'm sorry, so if Justice Ara's example of smelling a strong odor and the car moving, that could have been enough?
I'm not sure if that alone would be enough, but if it was also true that the officers saw a lit cigarette or saw smoke, then the officers would have there's a greater probability that there is present consumption at the same time that there is driving.
Or they swerved or something.
Yeah, my
Right.
concern with that, though, is I think that's what the Court of Appeals is saying is maybe sufficient to establish probable cause. And we know reasonable suspicion is a lesser degree, a less burdensome standard, right? So is there any, and what you're saying to me sounds like, well, reasonable suspicion and probable cause are going to sort of collapse on each other in this instance. Is that true, or is there some daylight between what is enough for probable cause, but you know, you need a little bit less for reasonable suspicion?
I think there is daylight, and as Justice Welch is indicating, if a car is also swerving, then that's, I think now there's actual probable cause of a traffic violation, of a person actually being intoxicated, in addition to just the possibility that somebody in the car is consuming marijuana. I think that there is daylight, but I think that the statistics around and this this study that was cited by the Minnesota Supreme Court suggests that there is a concern with operating on the basis of smell alone, whether it's in a finding of reasonable articulable suspicion or probable cause.
I'm sorry, is it not illegal to consume or smoke marijuana in the passenger vehicle, in the passenger seat of a vehicle while on a public street?
I believe that is carved out from the MRTMA as not, the MRTMA is not making that conduct legal, is not protecting that conduct.
So why do you need to have the vehicle swerving like a drunk driver? If there's strong odor coming from the vehicle and you're on the public street, isn't that enough under Terry to investigate further?
I'm sorry, in your question, is the officer also seeing indicia of present consumption?
Doesn't see the consumption, but I mean, I'm telling you from my personal experience, I can tell the difference between an old odor of marijuana and a very fresh odor of marijuana. I mean, the strength, I don't think it takes an expert to figure that out. And I think, I don't think it's an unreasonable assumption that police officers know more than me. So if you go by a vehicle and there's a very strong odor that seems to be coming from that vehicle, and it doesn't require that there be operating of the vehicle. If you're smoking marijuana or consuming marijuana, it doesn't even have to be smoking, I guess. If you're consuming marijuana on a public street, that's not protected conduct. So doesn't that give rise under Terry to investigate further?
And again, my answer is no, because there's no indicia of present consumption, and I understand Your Honor has a position about your own ability to distinguish something that's been smoked recently, but again, it could have been, that could be a fresh odor that the passenger of the vehicle was in close proximity to, again, earlier in the day.
It could have been, right? It doesn't have to be rock solid. We're talking about the first level is Terry. And does it have to be proof positive under Terry? No, reasonable suspicion.
It doesn't have to be proof positive, but the Ohio versus Terry decision, which gives officers this ability to conduct an investigatory stop, goes on at length about how the officers in that case observed John Terry to be, the officer had made observations over some 30 or 40 minutes, and I think Chief Justice Earl Warren makes a point of the fact that the officer is able to distinguish this person's behavior as distinct from others who are simply window shopping, right? The officer's concern was, this is a person who's preparing to rob a store, and there was a particularized basis to believe that this person was doing something more than simply window shopping. And my argument is that when an officer is simply smelling marijuana, their suspicion is of the analogy to window shopping. The likelihood of an innocent explanation is too high to permit the officers to be essentially seizing everybody on the commercial in Terry versus Ohio, for the officer to be seizing everyone on the block on suspicions that they're preparing to conduct an armed robbery just because they're peering into the window of a store.
And I think, counsel, it's, I mean, wouldn't it be that we sort of have a clash? We have this legalization of the use of recreational marijuana. We have a purpose statement in the law about wanting to make sure people can freely use it without, getting in trouble. But then we also have this carve out for using it in a vehicle, and obviously, so you have this right in other contexts to use it freely. And then obviously what we're grappling with is, but there are some carve outs that accept that. So I mean, I hear what you're saying.
Right.
That because it's very legal, now it's like, well, if you smell it, does that mean you were doing something unlawful in the vehicle? So that,
Right.
from my perspective, that's like the difficult thing we have to grapple with.
And whether that conduct is a civil infraction or a misdemeanor, does that inform the question of reasonable suspicion or probable cause?
On the question of reasonable suspicion, Terry versus Ohio makes clear that the officers need to have reasonable articulable suspicion of criminal activity.
Criminal activity.
So I think that, yes, the suspicion of a civil infraction is not enough for an investigative stop under Terry.
And was it your position that what potentially occurred here, if, I understand you're saying it didn't, but it was a civil infraction?
Yes, and I think that the government in their brief on page 10 of the brief at the Court of Appeals level concedes that public consumption of marijuana in public is a civil infraction.
But there was also a driver in control, in the driver's seat, right, who arguably was in control of the vehicle, and driving is a criminal misdemeanor, or being in control of the vehicle, right, under?
Right, that is criminal. It doesn't justify officers seizing the passenger of the vehicle. And even if this court found that there is reasonable articulable suspicion of criminal activity on the basis of the smell alone, as the court, I think, earlier noted, under Florida versus Royer and the United States versus Rodriguez, any seizure, any investigative stop has to be tailored in scope and duration. An officer can only conduct that seizure as long as is necessary, a prudent officer, to confirm or dispel their suspicions. And in this case, once the officers get close enough to the vehicle to see that there's no smoke and there's no lit cigarette, the both individuals are able to answer questions coherently, they don't see any other indicia of intoxication, that seizure needed to end under Florida versus Royer
Well,
and United States versus
but then that
Rodriguez.
goes into, like, I believe the prosecution's theory is that they needed reasonable suspicion to be in the position in which the officer testified or took the position that she could see the weapon in plain view. So yes, maybe the investigation at that point should have been limited in scope, but then the weapon was visible in plain view. Do you want to address, I understand that the trial court, and this is a little bit of a unique way that this record was created, right? We don't have witness testimony in that. We have limited to a body cam and a few lines from a police report, right? And so that was stipulated by everybody that that's what we're going to decide this case on. And so, but their contention is that as long as they were legally at the window, then the vehicle was seen in plain view.
The
Weapon was seen in plain view.
I understand the question. The trial court made a factual finding that the gun was not visible to the officers until after Mr. Armstrong was removed from the vehicle.
What was that finding based on?
That was based on the trial court's ability to watch the body-worn camera. And within the body-worn camera, one thing that the trial court highlights is that after the gun is found by the second officer, Officer Ganaw, that the gun is removed from the vehicle by that second officer. The first officer turns to the second officer and says, "Ooh, let me see it." And the trial court makes a finding that the officer saying, "Ooh, let me see it," is consistent with their not having seen it before, seeing it for the first time, essentially. I think that the Court of Appeals also noted that the officer, Corporal Eaton, the first officer that's speaking to Mr. Armstrong.
But I'm sorry. I just want to make sure that we have the facts of the records straight. Prior to that, though, didn't the officer say that he has a pistol in the car, and when the defendant objected, she said, "You can see it," before she said, "Let's see it real quick. Oh, nice."
No. That's not my memory of the body-worn camera. And
I think, wasn't it that the officer Gano was at the thing and asked, you can hear her off camera saying, "Do you have a CPL?"
Right.
And he says no, and then when Eaton goes back and says, "Hey, let me see it."
That's correct.
I've got one more question for you. I know your time is up, but I drove 7 hours to get here, so I'm not going to let you down until we're done with the question.
Fair. I drove as well. It's a beautiful drive.
So we can take as much time as we need. Assume the officer had legal justification to seize the vehicle and investigate whether illegal activity had occurred. Is there any reason why they would not have been able to order the occupants to exit the vehicle during the course of the investigation? Doesn't officer safety concerns apply just as much here as it would in any other traffic stop?
Well, I think, first of all, I dispute whether this is a traffic stop. There's no...
No, I'm not saying it
Yeah.
isn't.
Okay, sorry.
But officer safety concerns, legitimate, right? The Supreme Court of the United States has told us that's a very legitimate reason to take precautions. And I'm asking whether, in this circumstance, wouldn't those safety concerns be just the same as if it was a traffic stop?
I would cite to this court's earlier opinion, this term in People versus Duff, that whether a police officer's prudential procedures are justified has little bearing on whether a reasonable person might feel free to leave or otherwise terminate the encounter. The position that officer safety is not a substitute for reasonable articulable suspicion. And so if officers...
But the question I asked you to assume that existed already.
If officers had reasonable articulable suspicion, I think Terry versus Ohio holds that once officers have reasonable articulable suspicion and then they also have a basis to believe that a person is armed and dangerous, then they conduct a pat-down. And so I think that following from Terry versus Ohio, there should be the first and then also the second step where there's some basis to believe that this person is a danger, in order to take the additional, to escalate to the additional step of removing somebody from a vehicle. Pennsylvania versus Mims, of course, is distinct because it's a traffic stop and officers had probable cause, having seen a traffic violation. Here, if we're sort of bootstrapping officer safety on top of the reasonable articulable suspicion, I think that that's an extension of Mims that's not necessarily consistent with Mims.
Thank you.
Thank you. Thank you all.
Thank you, Chief Justice, and may it please the court. My name is Ramos Fadood. I'm here on behalf of Amicus Curiae, ACLU of Michigan. Now, the defendant appellee has already addressed the core argument about the role of the smell of marijuana, and we agree with those arguments wholeheartedly. I want to instead focus my time on two unique arguments made in our brief. The first being that under Terry v. Ohio, police stops that are based on reasonable suspicion cannot be used to investigate civil infractions categorically. And the second, if I end up having time, is that the search and seizure provision of the Michigan Constitution provides greater protections than the Fourth Amendment to prohibit police stops based on nothing more than the alleged smell of marijuana. Now, as to that first argument about the categorical limits of Terry stops, the prosecution today, and in this case, makes a dangerously broad argument that police officers can conduct Terry stops based on reasonable suspicion of civil infractions, such as smoking marijuana in public. However, Terry v. Ohio doesn't allow the use of police stops to investigate civil infractions if they're based only on reasonable suspicion of that offense. Instead, Terry and the case law developing it repeatedly make clear that only indicia of potential criminal activity can provide reasonable suspicion to conduct an investigatory stop, and I welcome the court's questions at any time.
So can you lay out for me what is, I believe the prosecution says it's both criminal misdemeanor and civil infraction. What is what, right? Like consumption on a public street is a civil infraction.
That's correct, Your Honor.
Consumption in a passenger compartment of a vehicle is
It is also a civil infraction for the passenger.
What about the somebody sitting in the driver's seat of a vehicle?
So being in control of a vehicle while intoxicated by marijuana or while consuming marijuana is a misdemeanor, and that would require this court to reach that core primary argument about what role the smell of marijuana alone plays in reasonable suspicion analysis. We think that the smell of marijuana alone, as the defendant argues, does not provide reasonable suspicion to conduct a stop even on a parked car. But as to the civil infraction of smoking marijuana in public, whether or not there was reasonable suspicion, a police officer couldn't have used a Terry stop to investigate further because the Terry stop, the Terry doctrine is limited to criminal activity.
Is your theory, though, that for civil infraction, that the relevant standard under Terry should be the higher, the more burdensome probable cause standard?
Right. So essentially the rule we're advocating for here is a probable cause minimum for investigating civil infractions. Terry v. Ohio recognized a limited, very narrow exception to the general probable cause requirement because it recognized the government's interest in fighting, detecting, preventing crimes. It recognized that was a compelling enough interest to warrant a bit more flexibility than what probable cause provided. But the interest in investigating civil infractions isn't as compelling, isn't as urgent as fighting crimes. And so the police shouldn't be afforded the same level of flexibility for civil investigations that Terry provided for criminal investigations. And that's—
Counsel, can you help me understand, I understand what you're talking about as far as reasonable suspicion versus probable cause, civil infraction versus not. But I'm looking at the law, and I know this is getting into the weeds of the law, which we have not asked the parties to totally brief here, but we talk about consuming marijuana while operating, navigating, or being in physical control of any motor vehicle, skipping ahead, or smoking marijuana within the passenger area of a vehicle upon a public way. That's a misdemeanor. That's how the law is drafted. How does that not apply here? How do we jump to just public use, which I is a civil infraction.
Well, I mean, I don't think it's in dispute that one of the alleged bases for the police's stop here was the civil infraction of smoking marijuana. That's what the prosecution alleges in their briefing. That's what the defendant agrees with.
So we're
And
just going with based on how the case sort of came to us?
Right. For this
Okay.
particular case, the prosecution maintains that the police were investigating the civil infraction of smoking in public. That's what we have to respond to. And what we believe is that, reasonable suspicion or not, the police did not have a Terry stop on their investigative tool belt for investigating that civil infraction.
Go ahead, I'll let you finish before I ask my question.
No, go ahead. Go ahead.
Well, I don't read the prosecution's brief the same way you do, but the facts are the facts and the law is the law. What we have here is a vehicle with 2 people in it and a strong smell of marijuana. Does that not give rise to a reasonable suspicion of a misdemeanor under our law?
We believe not, Your Honor, and I think I understand your questioning of the defendant and of me. It's a jarring kind of new landscape after the MRTMA was passed, where the use and possession of marijuana is generally lawful, except for a limited set of exceptions where it remains a misdemeanor or a civil infraction. And I think I want to point this court to the U.S. Supreme Court's decision in Reed v. Georgia to kind of give a helpful guidepost for analyzing reasonable suspicion under this kind of post-MRTMA landscape. In Reed v. Georgia, police officers stopped 2 individuals at an airport on suspicion of drug trafficking. What they were going off of for that stop was simply that 2 individuals arrived in the early morning with little to no luggage, and they were standing in different places in line even though they were clearly together. What the Supreme Court said in that case was that all of those factors together, that totality of the circumstances, and I quote, describes a very large category of presumably innocent travelers. And I think that is a really helpful guidepost for the post-MRTMA world in Michigan, is that the smell of marijuana now describes a very large category of presumably innocent people. And so the police officers, I understand it might be a difficult change because it is a substantial change to the criminal law and procedure in Michigan. But now, after Michigan voters passed the MRTMA, the smell of marijuana points to a very large category.
Aren't there a lot of situations where things are highly regulated, like controlled substances, prescription drugs, where you can use them lawfully in certain situations and not in others? Even possession of a firearm, highly regulated, lawful in some situations and not in others. And we ask police officers all the time to make difficult decisions when somebody is possibly violating the law. Why is this? You seem to be trying to create this big bubble around marijuana that you can't go anywhere near marijuana because it's a zone of, because of this new law. I sort of disagree with the premise, this jarring change. We have changes to the law all the time. Something's made illegal that was legal before. Something's made legal that was illegal before. That's what's happening here. And so why isn't it just a simple question of, if this is a misdemeanor, which I think it pretty clearly is because this conduct is an exception to the protections under the MRTMA, and if it's true that it's a criminal offense, why can't the police investigate it like they can every other criminal offense? Why should we treat this one differently?
Well, so 2 things to that, Your Honor, if I might. I know my time is up, but the first thing is that the marijuana is scientifically unique for the reasons that the defendant mentioned. The smell of marijuana can linger on someone's body, breath, clothes, upholstery for hours, maybe even days at a time. And so we think this uniqueness about marijuana, I think, is warranted in that simply the smell of marijuana doesn't mean that someone is actively consuming, doesn't mean that someone's intoxicated. And the second thing I'll say is that the police still can investigate unlawful forms of marijuana use and possession, but what Terry requires is indicia of criminal
activity. They have to find somebody smoking a joint, or that's it?
Not necessarily smoking a
that we
joint,
have left?
but for example, the conduct alleged in this case, whether it's smoking in public or consuming marijuana while in control of a vehicle, you should be looking for
It's almost like
indicia.
you're arguing we can't have circumstantial evidence of this offense.
Well, I think the circumstantial evidence that would rise to the level of reasonable suspicion in this case would be things like smoke emanating from the vehicle. If the police had conducted simply a consensual encounter, if Officer Eaton had walked up to Mr. Armstrong without the other officers surrounding the car and then had seen a lit cigarette on the dashboard or other marijuana paraphernalia on the dashboard, officers can still conduct consensual encounters. What happened in this case, however, is 5 officers surrounding a vehicle simply because they smelled marijuana. So I want to emphasize that what we're arguing here isn't to remove the entire investigative tool belt from police officers when marijuana is involved. It's simply removing certain tools on the tool belt when there's just the smell of marijuana. Officers can still conduct a consensual encounter. Officers, if they have probable cause of a civil infraction or reasonable suspicion of a crime, can still conduct a Terry stop, can still arrest if they have probable cause. But it's really about the smell of marijuana alone giving rise to reasonable suspicion. And that's really just one tool on a large tool belt that police officers maintain after the
Counsel, does it
MRTA.
matter, I know Minnesota grappled with this, and they cited to data that only in 9.4% of the cases, based on odor of marijuana, did they find actual marijuana. Does that matter to our analysis?
I think it's helpful background. I mean, obviously, a crime is a crime, and if police officers are investigating a crime, the likelihood of recovery is I think is helpful and relevant. But what matters more for in jurisprudential terms is whether or not there was the adequate level of suspicion to initiate the stop. And in this case, again, there was a stop. Officers surrounded the car. All forms of egress and ingress were blocked. But all they had to go off of was smelling marijuana as they passed the vehicle. Not particularized to the driver, not particularized to the passenger, but simply smelling marijuana as you drive a vehicle, I don't think rises to the level of reasonable suspicion for the reasons I pointed to in Reed v. Georgia. It now, after the MRTMA, describes a very large category in the state of Michigan of presumably innocent people. And I think given the change in the law, police practices need to adjust a bit. And that's, it boils down to the purpose of the Fourth Amendment, which is to restrain police conduct. And not to eliminate police discretion, but to restrain it so that it prevents unreasonable searches and seizures. And I believe that what happened in this case was an unreasonable seizure.
The Michigan Rules of Evidence permit a court at any stage of the proceeding to be able to take judicial notice of a fact. Do you disagree with the notion that the everyday person can tell the difference? Not even the trained police officer, but the everyday person can tell the difference between a strong smell of freshly smoked marijuana versus the smell of marijuana that is hours or days old?
I don't know, and I don't think the average person can do that. But even if there's an easy way to distinguish between freshly smoked marijuana and marijuana that was smoked hours before, I think this case actually presents a perfectly good example why simply the smell of freshly smoked marijuana isn't enough for reasonable suspicion. It could have easily been the case that Mr. Armstrong, who was a passenger in the car, had smoked marijuana in a home minutes before entering this vehicle. And so I don't think the freshly smoked nature of marijuana necessarily is unique in that it gives rise to reasonable suspicion versus just the smell of burnt marijuana.
We all agree reasonable suspicion is less than probable cause. Once you're sitting in the car and there's this strong smell, why isn't that reasonable suspicion?
Well, I mean, reasonable suspicion.
Maybe it is innocent, maybe it's not. But I have reason to think there may well be a misdemeanor that's been committed here. Let's go to the next step.
Right, but Terry v. Ohio, I mean, reasonable suspicion is looser than probable cause, but it's still a minimum that rises above the types of inchoate hunches that Terry v. Ohio was talking about. And what the MRTMA sought to do, both in its purposive section and its operative terms, is to sever that hunch, that connection between the smell of marijuana and assuming that, something around me, something criminal must be happening around me. I think that was the purpose of the MRTMA, and it accords with Terry v. Ohio and the case law developing it.
Thank you.
Thank
You've all
you.
been very helpful.
Why didn't your office ask for an evidentiary hearing?
That is something that, as the chief of training for our office now, I have yelled at many people in our office for not doing so.
Because it puts us in an interesting position on appeal where if the officer had testified that she saw the gun in plain view, then I think unless there's contrary evidence, it would be clearly erroneous for the trial judge to find otherwise. But now the judge gets to apparently find whatever he or she wants based on some stray comments in a video. What are we to do with that?
I don't disagree that there really should have been an evidentiary hearing in this particular case.
It's your burden, just so the audience understands, right?
Exactly.
To prove that the stop, the brief investigatory stop under Terry was lawful. We're not talking about arresting anybody. The question is whether there can be a brief detention to further investigate whether criminal activity occurred. And that's your burden to prove, right?
Correct. Certainly we would have been in a much better position as the prosecution arguing this in the circuit court if there would have been an evidentiary hearing. But I still feel as though the facts that do exist.
And just to clarify one further
Sir.
thing that you said earlier, you said that the officer, somewhere there's an indication, I haven't found it in my materials, that there was a furtive gesture in the car. Where did that come from?
That came from the video, Your Honor.
So
Is that she
made mention of that?
after the actual stop, the video keeps going on for several minutes, and in in the video,
The
that
audio,
particular
isn't it
officer,
the
Officer
audio?
Eaton, states many times that I saw a furtive gesture. I saw a furtive gesture.
Does she specify when she saw it?
She indicated that she saw it as they were walking up to the car.
And again, just for the benefit
Which
of,
we have video of that
Correct.
shows her walking up to the car.
Yeah, and
For
I'll
the-
concede that the video doesn't show
Doesn't
any
show the
furtive gestures prior to her going to the car.
yeah, for the benefit of the audience, isn't one of the reasons the police might come on both sides of a vehicle is because they're concerned about officer safety?
Correct, Your Honor.
And if there's an officer who thinks there's a furtive gesture in a car, it might be something like putting a gun on the ground in the vehicle or trying to place it in the console or under the seat?
Exactly.
All right, so this is why this is sort of standard police practice.
To go to both sides of the vehicle. And also, in this particular instance, because they were investigating both the driver and the passenger for the smell of marijuana, which
Well, there were 5 officers there around the vehicle, and 4 of them around the vehicle by the time that Eaton walked up, correct? But they were there to look for probationers or parolees,
it was, it was a checkup on a parolee that lived in that area, correct?
not one of the occupants of the vehicle.
Not one of the occupants of the vehicle, right. So 2 things I did want, as rebuttal, I did want to touch upon, and
Very briefly.
very briefly, because I know that we're way past it.
But I hate to keep interjecting that. On the issue of whether it's a misdemeanor, do you agree with the amici counsel that you didn't argue this was a misdemeanor offense? You argued it was a civil infraction?
I wholeheartedly disagree that I didn't argue that this was a misdemeanor, because part of it is the fact that the driver, whether or not the driver was smoking marijuana, that is a misdemeanor. And that's what they were also investigating. They were investigating, it was sort of a dual investigation. One being the driver, whether the driver is committing the misdemeanor of smoking, being under intoxication or smoking in the vehicle, under the control of the vehicle, or the passenger was smoking within the confines of the vehicle or smoking in public. So you can't parse out that we're only investigating the passenger for a possible civil infraction, but we're also, we have reasonable suspicion to investigate the driver.
But how do we know what they were investigating if we didn't have an evidentiary hearing?
Because.
I mean, it seems like we have to kind of know, right? We're just gonna assume both officers, they were investigating both things, just take them at their word for it, even though we don't.
The investigation was for the smell of marijuana emanating from this vehicle. There's 2 individuals in there. The investigation is to both individuals. I mean, that's what's on the video. So, going back to what I wanted to rebut on, is first of all, is that I will agree that marijuana does have uniqueness, and the fact that we're way past the days of Cheech and Chong, with police in the movie come up to a vehicle, and I'm dating myself, I know entirely by saying Cheech and Chong. Police come up to a vehicle and smoke is emanating out of, and they have joints. My experience now is that most people that are smoking marijuana are using vape, which is very The water vapor that is used in the vape dissipates very quickly. It's not a joint. It's not something that they're physically holding and rolling for the marijuana. It is like the marijuana. I don't know how the vape's used, but it is not as easily apparent from smoke and roaches in the
But it
the
creates
ashtray.
just as much odor.
Correct?
But it creates just as much odor.
It does.
Vape.
It also
Right.
produces visible smoke.
But it quickly dissipates much quicker
Sure.
than the smoke. So that's the first thing I wanted to mention. And I think we did address the second thing I did want to mention, which was which was relating to Justice Viviano's question. Other than that, any further questions?
What are you asking the court to do?
What I'm asking the court to do is to reverse what the Court of Appeals did, which was to find that Kazmierzak is no longer good law, because I don't even believe that we should even be getting to the question of Kazmierzak.
Because the question is about reasonable suspicion, right?
Right,
And the Court of Appeals missed that somehow, right?
exactly.
So where do we send the case if we were to vacate, if a majority agreed that we should vacate the Court of Appeals opinion and the part dealing with probable cause and send it back for reasonable suspicion analysis? Does that go to the trial court? And if so, would it be again based on the video? What does a remand look like?
Well, I think a remand could go to the Court of Appeals to determine whether or not there was evidence that would support reasonable suspicion. It could go down to the circuit court.
You're pretty much stuck with the video at this point.
I'm stuck with the video, right, exactly. And so it could be that on the existing record that the circuit court, and I know that Justice Hood is no longer sitting in the circuit court, he's now at the Court of Appeals. So that'd be a different judge. They'd have to review,
But if we find that it is not sufficient for reasonable suspicion, the odor alone, then obviously it's also not sufficient for probable cause, correct? I mean, because reasonable suspicion is a lesser standard. So if we say whatever the lower courts did, or, how it was presented to them, and they decided it based on probable cause, but we think actually the correct inquiry is looking at reasonable suspicion, if we were to conclude that the odor alone isn't sufficient for reasonable suspicion, then it couldn't be sufficient for probable cause either.
Well, I need, for some kind of specificity, or would the court be saying it's not reasonable suspicion to do the investigation, or not probable cause to do the search, getting to? And that's what Kazmierzak deals with. So if the court is saying that the smell alone is not reasonable suspicion to even do the investigation in the first place, and certainly there isn't probable cause to do the search itself. I think here in these facts, you still deal with the fact that Kazmierzak is still law until this court rules, and that the smell of marijuana under this court's decision, just the smell alone is probable cause to go into the vehicle. And so you have a good faith exception to this of whether or not there should be suppression of that. But that's moving forward. I guess the question would be whether the smell alone is enough to investigate or to search.
Thank you. Thank you all. The case will be submitted.
Thank you, everyone. Please go ahead and have a seat. If you'll give us just a second, we need to set up for the debriefing and the Q&A that is about to occur. So hello again and good morning, everyone. I want to start by saying I was in private practice for about 10 years before I joined the court, and like arguing in front of any court can be a little bit nerve-wracking, and arguing before the Michigan Supreme Court can be particularly stressful, but doing that in an auditorium with judges and high school students at your back is kind of above and beyond the call of duty. So if I could get a hand for the attorneys who are here today. I'd like to thank everyone in the audience for coming. I'd like to thank the justices who came today. And a lot of us came yesterday, some even before, and we've had a great time exploring Marquette and some of the other great sights to see here in the Upper Peninsula. It's really been wonderful. And I want to thank everyone from the county who helped put this program together, and everyone from the court who also did a lot of work putting the program together. One of the things that I really enjoy about being the chief commissioner is that after the oral arguments, I usually go back and I sit with the justices and I kind of take notes, so I get to know exactly what's going to happen. I have no idea what they're going to do now, but I do know that the justices are meeting. They're talking about the briefs that they read. They're talking about what happened in oral argument. They're talking about the questions that were asked. And they're picking each other's brains to try and figure out, like, well, what do we want to do now? They have a whole range of options available to them at this point. They could simply do what's called deny leave to appeal, and that would just leave the Court of Appeals opinion in place. They could decide they want to reverse the Court of Appeals and do an opinion reversing the Court of Appeals. They could decide that the Court of Appeals got it right, and they could write an opinion that would affirm the Court of Appeals. They could even say, you know what, we need more briefing and more oral argument on this case, so they could do what's called grant leave to appeal, which would be another step, which is very rare, but they will occasionally do that, in which case there would be further briefing and further oral argument. If they decide to do something very simple, something might come out in a couple of weeks. If they decide to do an opinion, in all likelihood, there would be an opinion, there would be a dissent, there might be other statements. That could take months. It's a lot of work when they do opinions. The one thing that I do know is that justices have spent a lot of time and paid a lot of attention to this case. They've looked at the law, they've looked at the facts, they've looked at the parties' arguments, and they are back there having a civil discussion, listening to each other carefully and thoughtfully, and really considering every justice's point of view. So we're going to have, I think, about 25, maybe, we ran a little long, so I'm not sure exactly how long the questioning is going to go.
It wasn't our fault.
No, it was all those justices and their annoying questions. I think we're going to have about 20 minutes or so for questions and answers. I have a few questions that I can ask if the room goes silent, but I'm really hoping that that doesn't happen. Those of us who work on putting these things together, like, we really care about what you guys thought about what you just witnessed. We want to know. We want to get your thoughts and your comments and your questions about what just happened up here. So please do not be shy. If you have a question, if there's anything at all you're curious about or you want to ask the attorneys while they're up here, just raise your hand. I think someone will give you a microphone. You're going to come up to the microphones. So if you have a question, please come up to the microphones. And again, please do not be shy. Let's see. To kick things off, what I'm going to do is ask the attorneys to introduce themselves and say just a little bit about what kind of law they practice and what they do. And when we're in court, usually the appellant typically goes first, and in this case, that is the prosecutor. So if you would introduce yourself.
Well, is it morning or afternoon now? I think it's still morning.
I think it is. Yeah.
Good morning. I am John Voitala. I am the Chief of Research Training and Appeals for the Wayne County Prosecutor's Office. This is probably my 30th Supreme Court argument, and I've been with the Prosecutor's Office for 20-some years, all doing appeals, criminal appeals.
Okay. And our defense attorney.
Good morning, all. My name is Andrew Sullivan. I've been practicing law for about 8 years, primarily as a public defender, an attorney appointed to people who can't afford a lawyer. I just recently opened my own practice, though, and I'm still doing primarily criminal defense and a little bit of appeals. This is actually the first time that I've argued in front of the Michigan Supreme Court.
And we have a special guest with us today, an attorney for what is called amicus, or a friend of the court. So if you would introduce yourself and explain a little bit about what your role here.
Sure. So my name is Ramas Vadood. I'm a civil rights lawyer. I'm a lawyer who works for a civil rights legal nonprofit called the American Civil Liberties Union. We do a lot of things in the civil rights space statewide. And as you just mentioned, I'm what's called amicus curiae. It's a Latin term for friend of the court. What that essentially means is that I don't represent either party in this case. I don't represent the people of the state of Michigan. I don't represent Jeffrey Armstrong. I essentially represent my organization, a third party, who has told the court, we have something interesting and we think important to say about this case. We think we could be helpful. So if you would give us the opportunity to present it to the court, we would appreciate it. And the court accepted. And so we essentially invited ourselves to this party, and the court let us do that. So we're essentially a third party that doesn't have a direct stake in the party's case. But we just presented kind of our opinion on how the court should decide the case.
Okay, thank you, counselors. And with that, we will open it up to any questions from the audience.
Real quick, can you tell us what preparation went into, particularly with the lawyers, into getting ready for the hearing today?
Well, typically for my office is that we do a mock argument. And so it's our entire division. Sometimes if it's a big enough case, there'll be prosecutors from around the state that will all gather together. And what will happen is I'll go through my argument. The other attorneys will be the justices. They'll ask me the questions. And so it prepares me to know what questions might come from the justices and prepare for those questions, to give answers to those questions.
I've been representing Jeffrey Armstrong since 2021, so the preparation has been really since I met Mr. Armstrong and got familiar with his case and have argued it at the circuit court level and then again at the Court of Appeals and now today. And so the preparation in some senses, has been years, but just in preparation for today's event, I did ask a lot of friends to pick me, ask difficult questions and try to get me tripped up and sort of do moot arguments so that I was prepared for any question, theoretically any question that the court may ask.
Nothing substantially different for me, just a lot of reading. You can see my binder over there is full of cases that were cited in this argument. A lot of just preparing for the back and forth that you expect at the court.
Thank you. Next question, please.
I think it was Justice Viviano that mentioned the possibility of remand. Could you explain that, what that would look like or what that might mean? Because I'm sure the students have no concept of that.
Sure. What a remand is that once it gets into the appellate courts, so whether it's a circuit court decision by the trial judges at the circuit court level, it gets appealed to the Court of Appeals, or a case that eventually gets to the Supreme Court, either of those courts, the appellate courts, can make a determination that I need additional evidence that is presented in the circuit court, or I need the lower courts to reach a particular decision on a case before we, as the higher appellate court, can reach a decision. And so what would happen is, in this case, what Justice Viviano was referring to is, the unfortunate thing in this particular case was that, and he alluded to this, is that we did not, as the prosecution at the trial court level, did not insist upon having an evidentiary hearing. And what the evidentiary hearing would have been is we would have brought the police officers to come in and give a testimony about what they did, whether they saw anything, what they smelled, all the things that were relevant to this particular case. We had a very young APA, an assistant prosecuting attorney. She did not conduct the evidentiary hearing, and so there are some gaps in the evidentiary record. And so that caused a problem on appeal. And since then, as I said, I've told our assistant prosecutors, you need to hold an evidentiary hearing in every one of these cases where there's a question of suppression. Nonetheless, what this court can do, which Supreme Court can do, is if they feel as though they need more evidentiary, which I don't think that's really where he was going with this, if they needed more factual evidentiary record, they could send it back down to the circuit court to hold a hearing. Once that hearing is done, then it would work its way back up to in the appellate courts. Or in this instance, if there was the issue that we raised as the prosecution was that whether or not there was reasonable suspicion, whether the smell of marijuana gave the police officer reasonable suspicion to do the investigation. That was an issue that really the Court of Appeals did not address. They only addressed whether it was the smell of marijuana was probable cause to do the investigation, to order a defendant from the vehicle, to do the search of the car. They really did not address the reasonable suspicion question. And so what Justice Viviano had indicated was that perhaps a solution to this is to send it back down to the Court of Appeals so they could address the reasonable suspicion question.
I want to offer one piece of context about the evidentiary hearing as well, just that everyone, I know it's maybe in the recesses of our memory, but we were going through a global pandemic actually at the moment that we were making this decision about whether or not to hold an evidentiary hearing. And so to give some credit to the prosecutor's office, the decision to go without an evidentiary hearing allowed the case to move forward, where we may have stalled for a very long time trying to schedule an evidentiary hearing as everyone was sheltering in place. We don't yet do evidentiary hearings, or I actually, on Mr. Armstrong's behalf, wouldn't have allowed us to do an evidentiary hearing virtually, because it's much better if you're doing a cross-examination of an officer or any witness to be able to be there in person with them. And so I think that if we had, the case has taken quite some time to get to the Michigan Supreme Court, but the delay would have been much longer if we had had an evidentiary hearing.
Next question, please.
So you had, I don't know if you can hear me, but you had 6 people like asking you questions. How do you deal with maintaining like a singular point? Because everybody has to ask something, and you have to stay in kind of a row if you can. How do you deal with it? And everybody has a different philosophy. How do you deal with those different questions at once?
You want to take it, or?
Yeah, I mean, it's really hard. I mean, a lot of people up here asking you questions, and unlike, a lot of, this isn't just like an interview where they ask and you answer, they move on. Like, they're going to press you if you don't give them an answer. So, what I've been taught and what I try to do in arguments is answer the question directly, but then get straight back to being in control of my own argument. I have a whole sheet of what we call pivot points, like just, the top line of this is really what I want to get across. And I got to find a way back to getting on track after answering a question. It can't just be answer, pause, wait for the next question. Always, try to take control of the argument once you're done answering.
I think that's great advice. I don't have anything to add to that.
It's very, very difficult to do this, especially because of a lot of times the questions that the judges give you are to set up another question that's going to come much later. And so, you get that a lot with the justices, is that they're asking you a question, not so much to get to what your answer is to that, but to move it towards a different question and sort of set the parameters for that other question. And so it's difficult sometimes to make that connection, even though in the justice's mind it may be pretty clear. Yeah, it's probably the most difficult part of doing these arguments, is to keep all the questions and straight and still make your argument, and not to get lost down the rabbit hole of the questions themselves, is to answer the questions, get back to where your argument and the points you want to make.
I should say another great thing about my job is I don't have to be in the position that these people are in. Next question, please. Oops. You want to go ahead? Thanks.
You mentioned a positive about not having an evidentiary hearing. What are some of the negative consequences that you're facing now about not having one?
To me, it's all negative that we didn't have an evidentiary hearing in this particular case, because it certainly would have made, if done properly, we would not be here if an evidentiary hearing was conducted in this case, because we would have had all the questions that came out of the lack of evidence, the lack of record that we have as to, what did you smell? When did you see the gun? When did you, who were you investigating? All of these questions would have been answered at the evidentiary hearing stage. And so when we went, if the court had ruled the same way and we went to the Court of Appeals, I, as the prosecutor, would have a lot more evidence to present to support my arguments as to why this was a proper investigation and seizure of the gun. So yeah, I see no negatives for me not to have the evidentiary hearing. Or I see no positives for it. There we go. No positives to not have an evidentiary hearing.
Yeah, I don't have a lot to add. I guess I would just say it's still possible that we could have been here if the evidentiary hearing had resulted in the court still making the same rulings about when police officers observed what they observed. It seems like one of the disagreements between the parties here is when police saw this gun, and the circuit court sided with the defense that it wasn't within plain view until after Mr. Armstrong was removed from the vehicle. If the evidentiary hearing had supported that, then I think that the question still would have been sort of raised the same way up on appeal.
Thank you. Next question, please.
Yeah. So I'm kind of curious about the fact that this hearing is done so incredibly differently than trial courts are, in the way that it doesn't feel like two attorneys are arguing with one another, more that two attorneys are being questioned by a panel of judges. And so my curiosity lies in whether you feel as attorneys there's like any distinct advantages or disadvantages in litigation when you take this format of hearing versus just trial court calling up people, having them answer questions, opportunities to object, things like that. This is you just delivering an argument. So do you feel that it's better or worse off for you as an attorney giving your argument kind of in a fashion that's uninterrupted by the opposing side as much?
I certainly enjoy it a whole lot more. There are trial attorneys and there are appellate attorneys. And there's people that love to be in court and they love to question the witnesses and they love the combat. And it's not, obviously physical combat, but there is, an adrenaline that comes with being in a courtroom and having that kind of tit for tat between the two opposing attorneys, and add in the judge or add in the witnesses, and it becomes a very exciting in some cases. I'm not that type of person. I mean, I am very much into just looking at what the facts are and finding and arguing what my position is based upon what those facts are, and that's why I thought that it was a mistake not to have an evidentiary hearing, is because I would have had much stronger arguments had there been an evidentiary hearing and more evidence there. So it's just, for me, I love being in the appellate courts. I love doing appellate work because it allows you to make your argument uninterrupted. It's what your argument is. Most of our, it's very rare that we actually get a chance to argue our briefs, because the Court of Appeals, you have the right to appeal and you can certainly appear for those. In Wayne County itself, we have so many appeals. We are the largest, the busiest court. We are one of the busiest courts in the whole country, and so we're not able to argue every single case in the Court of Appeals, and the fact that in the Supreme Court, it's a rare occasion, as you, in your introduction, there are 1,500 applications and 80 cases, and not all of those, and maybe 40% of those are criminal cases. So, wow, I'm just talking and I'm not really answering your questions. I apologize.
All right.
It's just old habit, I guess. But it's just, for me, it's just the right format as an attorney, is to be able to give your argument uninterrupted, a good tit and tat between the justices, the judges, and yourself, And it's just, that's where my excitement comes from, and not in being in the courtroom.
I do both. Actually, more of my experiences as a trial lawyer. And one of the things that you're driving at is that on appeal, we're not actually disagreeing. We're not arguing about, we may disagree about the facts, but we're not arguing as much about the facts because the facts have been developed in a record. There's also a long process of briefing where the appellant writes a brief, and then the appellee has an opportunity to write a response brief, and amici can file. So there's just a lot of opportunity for everybody to have a heads up of what the arguments are going to be before we get here. Whereas in trial, you have some idea of what the witness is going to say, but they surprise you. And so there's a lot of having to think on your feet about that debate of what the facts are, but also if a legal issue can present itself that you maybe aren't prepared for, and you have to be able to have a lot more of the rules of evidence sort of at the forefront of your mind to be able to make arguments about why a legal ruling should go in your favor. I do enjoy that, and I actually also enjoy the extent to which doing some appeals informs my ability to be a better trial lawyer. And I think it is oftentimes the case that lawyers sort of pick one or the other. I've really enjoyed straddling the line, and I find that the two types of practice can inform one another, and there's no rule against doing both.
Thank you.
Thank you very much.
Hi. This question is geared more towards our friend of the court. I was really curious to know what kind of criteria the ACLU looks for when taking up cases, and maybe what about this case kind of fired you up or wanted to get involved in it.
Yeah, that's a really good question. I mean, we have opinions about a lot of topics. We're a very broad organization. The reason we pick this case and the reason we pick a lot of our cases is based on the impact they can have on others. Obviously, this specific case is about Jeffrey Armstrong, but the ruling in this case, whether a police officer can, go and stop or, the legal term is seize someone just because they smell marijuana, we think, affects potentially millions of people, across the state of Michigan. Just taking this audience, for example, we have a lot of people who are under the age of 21. If a police officer smelled marijuana somewhere in the audience, like we at the ACLU wouldn't want everyone under the age of 21 to just all of a sudden be a suspect in the crime of smoking while underage. So the reason we got involved in this case is because it doesn't just affect Mr. Armstrong. Obviously, we want Mr. Armstrong to have a good outcome, but it affects all of you as well.
Thank you. Yes, sir.
I thought it was only fair since this is mainly a crowd of students, but what's all of your guys' educational journeys?
Let's see. It was a personal story. When I was very young, I came home from baseball practice, and I found out that my father had been arrested. And he went through trial, got acquitted of the crime he was charged with. But what I viewed through his trial made me want to become a lawyer. And it wasn't so much because I wanted to be a defense attorney. And actually what it did was, even though my father was the accused in a particular case, it made me want to become a prosecutor because I saw the fairness that particular prosecutor gave to my father. And so that experience made me want to become an attorney. And so when I went off to college, I took political science classes. I went to DePaul in Chicago, and they didn't have a pre-law, but they did have political science as a major. And I took that as political science as my major. And then after that, I went to Wayne State for law school. And again, once I got to Wayne State, I had a professor there who later became my boss, who was a prosecutor, and that, again, just the way that he argued the law to me and taught me the law in law school is what really cemented in me. I want to become an attorney, and specifically, I wanted to be a prosecutor.
Interestingly, I have a similar story. My uncle is spent a lot of years incarcerated, and that motivated me to want to make sure that people get a fair trial. I suppose I just come to, similar motivation, different conclusion, that I prefer to work as a defense attorney. And yeah, you have to go to law school in order to be a lawyer. So my undergraduate degree is in engineering, so I'll offer that to you as an example of where you may decide after, to pivot after a different career path. Yeah.
Yeah, just really quick, like similar to Andrew, my undergraduate degree wasn't in law or pre-law. I studied hip-hop music in college. I was always kind of interested in law school, but became less and less interested throughout college as I got more into music and kind of the sociology of music. A couple things happened after college. A good friend of mine was killed by a police officer back home in Michigan. At the time, there were also just a lot of kind of legal and just like on the ground attacks against people that look like me. And that really motivated me to want to go kind of go back on the path towards law school and be a civil rights lawyer.
Thank you.
So my question to you is, you've probably got a lot of personal opinions on marijuana and other topics that you address. How do you not let your personal opinions influence how you are on a case, whether you're defending or prosecuting the case?
Oftentimes, it's a great question. I think that I feel oftentimes very lucky that my personal politics really overlap with my work. It's what brings me to my work. I think that people are entitled to a fair trial, and that I'm always able to see sort of the humanity in a person and the worth of a person that compels me to want to prevent them from spending years or their life in a cage. And so it's rare that I have any qualm with that. And yeah, I don't know. The state has a right to criminalize things and decriminalize things. And I think it's just, again, it's important to me that people always have a fair opportunity to present their case at trial, and also to be free from unreasonable searches and seizures, as we've talked about a lot today.
For me, and this is the absolute best thing about being a prosecutor, absolute best thing about being a prosecutor is every single time I go on the record, I say the words, John Voitala, representing the people of the state of Michigan. I don't work for the government. I don't work for a client. I work for the people of the state of Michigan. So my job is to argue for what the people of the state of Michigan have determined to be the law. And it doesn't matter if my opinion of what the law is any different. It is the people. We're in a democratic republic. We've elected people to make the laws. They've constructed the laws. It's my job then to argue what my interpretation, or what the court's interpretation has been of what the law is. And so that's where, that's what makes me able to argue things that perhaps maybe I don't personally agree with, is just the fact that this isn't, I'm not arguing what my position is. I'm arguing what is the position of the people of the state of Michigan.
Go ahead,
Hello.
please.
What's your most memorable case?
When I started practice, right out of law school, I got a job at the public defender's office in Memphis, Tennessee. And that public defender's office had a relatively quick turnover, so I became a relatively senior attorney early in my career by standards of that office. And so I was in the position of representing somebody who was charged with murder after she responded defensively to her abuser, and that was obviously very memorable. It was the first time that I was presented with the stakes of a person, the stakes of a murder trial, and I felt very lucky to be able to be Nicole Macon's attorney, and I also felt like an immense pressure to get her home to her family.
For me, I don't know if there's an actual appellate case that stands out more than the rest. I mean, every one of them is important at that time, and I've been fortunate that some of the cases I've argued have become, they're published opinions. They are the law that it applied, and they're applied. And when I write my brief, I see cases in which I was the attorney that argued it. The one case, though, that really, in my mind, that stands out there, or is the most memorable to me, is actually one that I didn't argue on appeal. It was in a motion for new trial. So what happens is, after a conviction, before it gets to the appellate layers, a defendant can make a motion for new trial, saying there's new evidence or a new witness or something else, some error that occurred that requires me to get a new trial. One case I had was very high publicity case down in the Detroit area. There was an individual named Robert Bashara, and he had a lifestyle in which an interesting sexual lifestyle that he did not want his wife to know about. And so he was afraid that she was going to find out about it, and he ended up having her murdered by a very low intellect individual. And so it had a lot of publicity. It was on national TV, and it was very up in the air. And so why it was memorable to me is that this is the first time that it's ever occurred to me in the court, and any time it's ever occurred since, is that, and again, I'm going to date myself. There was like this Perry Mason moment. And so there used to be this TV show Perry Mason, and inevitably at some point there was some unexpected thing that happened that changed the whole case. And so I had this with, as I indicated, the actual murder in that case had low intellect, and his name was Joe Gentz. And Joe Gentz was going to testify at this hearing, and I had zero idea what he was going to say, because he had gone on national TV and said Bob Bashara had nothing to do with this, and he had made confessions that said, yes, Bob Bashara did do this. And so he was all over the place on what he did and didn't do. I had no idea what he was going to say when he took the stand, and that's not a good position to be when you're an attorney. You want to know the answer to every question you asked. You don't want to put a witness up there that could either sink or your case. Fortunately for me, he did take the stand and was able to say, like, no, I did it, but he told me to do it, and he was the one who was responsible. And so to me, that stood out because it was so legally exciting for me. As I said, I'm not used to getting into the thick of combat in a trial court. So for me, that stood out because that was the first time that I really got that kind of rush of being in a courtroom where, I don't know what's going to happen.
I have to say, we see thousands of cases at the commissioner's office, but the one that was that I was thinking about over the weekend and the last couple of days is the case of the person who was accused of pushing their spouse over the cliff at Pictured Rocks, because that became very real to me on this trip. So, thank you very much. How are we doing on time, Raven? Okay.
Good morning. I just had a question regarding depending on the decision of the court in this case, would the state be interested in conducting a writ of certiorari and taking it to the federal Supreme Court? And if not, what are some types of characteristics in a case would the state or even a defense lawyer or a friend of the court look to potentially take a case to a federal Supreme Court?
I would say that there's a potential, I guess, depending on what the court does. If the court is going to rely on an interpretation of the Fourth Amendment, because we have both the Fourth Amendment involved here, which is the federal constitution, and Michigan has its own search and seizure amendment to its constitution. Generally, both of them are sort of interpreted identically. That's kind of coming into doubt as of late, but if the court reaches a determination that is so contrary to how the federal courts, the U.S. Supreme Court has relied upon, then that would raise the possibility of seeking a writ of certiorari. I do have one case that I've done writs of certiorari in other cases before involving, involving interpretations of the federal constitution by our state courts. And those are really the ones you need to get to, that have promised to go to the U.S. Supreme Court. Because it's their decisions that are being challenged by the decisions of the Michigan Supreme Court.
Do you want to say anything about federal courts?
I mean, yeah, it's just like the Michigan Supreme Court only takes a small sliver of cases that people ask them to take. The U.S. Supreme Court is just as, if not more, selective in the types of cases they take. There's, like John said, if one of the arguments I didn't have time to make was that, we also have a state constitution that has protections against unreasonable searches and seizures. If this court just rules on the state constitution, the U.S. Supreme Court, as a federal appellate court, doesn't really have much to say about a Michigan court's interpretation of the Michigan Constitution. So it's really when it presents an issue of kind of the U.S. Constitution, which is the Fourth Amendment is a part of, that we would go out and ask the Supreme Court to take the case.
I would say from our perspective at the court, obviously we don't have anything to do with cases being taken to the federal court, but we do pay attention to what the federal courts do. So if we have, for instance, our court has denied leave to appeal in a case, it's possible that a federal court will later come back and say, based on the federal constitution, they're going to give the defendant relief, for instance, that we did not. And so we pay attention to those things to see, well, what did the federal court think? How did they interpret this differently than we did, where we just denied leave to appeal?
But this court's not bound by what the federal,
No, unless it's the U.S. Supreme Court.
Unless it's the U.S. Supreme Court, yeah. But I could see it's helpful to see what the federal courts do in those particular cases.
Thank you.
Yep, thank you. Okay, that is all the time that we have today for the questions and answers. There's going to be a reception after this. If you were too shy to ask a question, I believe the attorneys and certainly the justices are going to be at the reception. And trust me, they're very friendly people. Feel free to go up and talk to them, ask them questions, or just introduce yourself and say hi. So I hope this has been a very good experience for you today, and thank you all for coming, and we will see you at the reception.